listener production.
A warning. This episode contains descriptions of death, violent crime, and mass killings. Please listen with care. Wrongful convictions are often seen as rare, tragic anomalies in an otherwise fair justice system. But when you dig deeper, a pattern begins to emerge. Overstated expert opinions.
He found what he regarded as bruises on the front of a left lower leg.
Unchallenged assumptions.
The conclusion was that Anna Chaney had been homicidally drowned.
And forensic science presented with more certainty than the evidence can support.
There was really only one person who could have done that. It was Mr. Keogh.
In today's episode, we examine one of Australia's most well-known miscarriages of justice, the 1995 murder conviction of Henry Keogh after the death of his fiancée Anna Jane Chaney.
An extraordinary case in Australian legal history.
A tragedy later established to be an accident.
People faint when they stand up in the bath, particularly if they stand up too quickly, if the bath's been a bit hot.
Our guest today is Professor Stephen Cordner, one of the world's most respected forensic pathologists. He played a key role in overturning Henry Keogh's murder conviction, a case built on flawed forensic evidence. My name's Liz Porter. I'm a journalist, true crime author, and forensic science obsessive. I've spent my career uncovering how forensic science cracks the toughest cases, writing 3 books on the subject and earning a PhD in the history of the Victoria Police Forensic Science Lab. Join me as I sit down with the world's top forensic experts and discover how forensic science is convicting the guilty and exonerating the innocent.
Let me say what a pleasure it is for me to be talking to you, because I had the privilege of writing a foreword to your fabulous book, Crime Scene Asia. And I mention that because not only is it a fabulous book, but in that foreword I mentioned that my own interest in forensics generally and forensic medicine started with a book written by Jürgen Thorwald. He opened the door to me through his books on sort of forensic stories, pretty superficial things in retrospect, but gripping to a 12 or 13-year-old reading them, having been given them for Christmas. So that was what sort of sparked my interest, I think, way back then.
You were hugely involved in a case, the Keogh case, which involved the death of a young woman called Anna Jane Chaney. Can you tell us about that case and how you first became involved in it?
The long and short of this case, which turned the South Australian criminal justice system inside out for 20 years, was that Henry Keogh and Anna Chaney were in a relationship, living together, and Miss Chaney was found dead in the bath by Henry Keogh. And the conclusion of the pathologist involved was that Anna Chaney had been homicidally drowned, and there was really only one person who could have done that, who was Mr. Keogh. So when the pathologist, Dr. Manock, examined Anna Chaney, he found what he regarded as bruises on the front of a left lower leg and 3 bruises in a row on the front of the left lower leg. I should sort of say now that as to whether they were bruises is indeed one of the issues. He took a histology section of one of those bruises, which became the subject of controversy about whether it demonstrated a bruise. The only other injury is bruising to the scalp. Other than that, there was no other injury. So, as I was asked to give evidence in 1995. Even by 1995, Manock had a particular reputation amongst the defence bar in Adelaide. There were very few cases where the defence was effective in combating the evidence of Dr. Manock. This is not my style. It's not the sort of thing that I would say. Anyway, I'm purely interested in the evidence and not who's saying it. And I remember saying to the barrister, as I tried to say to the court, that from a pathology point of view, there was insufficient material to conclude that Anna Chaney had been assaulted, let alone homicidally drowned. I said if this case had happened in Melbourne, we would have come to the conclusion that an accidental death could not be ruled out, that people faint when they stand up in the bath, particularly if they stand up too quickly, particularly if the bath's been a bit hot, particularly if, as in this case, the person fainting has had a couple of drinks, and Anna Chaney had a blood alcohol level of 0.08, I think, from memory, and had been out for a couple of drinks earlier in the evening. And she was having a bath prior to going out again, I think, with Mr. Keogh. So I felt, I could, and I did, and still believe today that the right conclusion for the court to have come to would have been, well, nobody can rule out accident here. And that's a hell of a long way from proof beyond a reasonable doubt that this woman has been murdered. And that should have been enough, in my view, in retrospect, for the court to acquit Henry Keogh. But as we all know, he got convicted, and that just started a whole chain of events which actually other people are much better qualified to talk about. In particular, Bob Moles, a academic lawyer in Adelaide, who is responsible for getting Mr. Keogh's conviction eventually overturned, and along the way got the law changed in South Australia so that if people like Keogh could demonstrate that they had fresh and compelling evidence, then they'd be able to get their case back in the court, despite the fact that they had had all of the appeals that they were allowed. And that's exactly what happened. Mr. Keogh got his case, was the first case to benefit from this new law, got his case back into the court, and he was pretty quickly acquitted. So it's an extraordinary case in Australian legal history.
And it's so interesting looking back on it is that the evidence that seemed so crucial at the time, which was the evidence from Colin Manock that bruising on Anna Chaney's left lower leg was a grip mark, which in his view was consistent with somebody forcibly holding her leg and then submerging her head underwater to drown her. What was your view of that evidence? You would have been looking at a photograph, I'm guessing, or her actual body?
Nobody's professional life is perfect, Liz, and everybody has things that they wish they'd done differently. And I wish that in this case I had argued the toss at the trial about those marks on the leg, because there are other causes of blotches on the leg, which include post-mortem lividity. Now, Manock said they were bruises. He took a small sample of one of them and put it under the microscope. And when you look at that sample under the microscope, there are a few sort of, and I'm using a technical term here, extravasated red cells in the periphery of the section. As far as he was concerned, that just satisfied him that it was indeed a bruise. That was an arguable conclusion. I accepted that. So I accepted that the 3 marks on the front of the leg were bruises. And my view was, I don't care. Even if these are 3 bruises, you can't say to any level of confidence that this is a grip mark. Everybody gets bruises on the front of their lower leg at different times and in different ways. And even if you have 3 of them sort of not all that far apart on the front of your leg, then, you might have scraped your leg underneath a table or on the side of a table or getting into the bath even. So didn't fuss me whether they were bruises or not, because in my way of looking at it, you couldn't say that that was a grip mark. Now, as it turns out, the jury must have believed that it was. And, I wish, in retrospect, that I had taken it one step further and argued the toss over whether these were bruises at all. Whether that would have made any difference, who knows?
Yes, I think you must at times be almost driven mad by wondering what the jury are actually thinking or what their understanding is. I'm thinking of the Kathleen Folbig case, which was covered so well in an interview with you by my predecessor, Catherine Fox, where you discuss at some length the fact that the jury entirely misunderstood the word asphyxia, thinking that it meant actual strangulation.
In that particular case, and I think I'm very reluctant to criticise juries, and I don't criticise juries. Juries are the ultimate consumers. They are entirely at the mercy of the 2 barristers and the judge about what they hear about a case. They're not allowed to go and do their own research, and they could land themselves in jail if they looked up anything on the internet or did their own research of any sort. And if the court found out about that, the trial would be abandoned and they'd start again, and the juror themselves would be in serious hot water. So it's no fault of the jury if they misunderstand something. They should have had it explained to them. But on the other hand, I agree with you entirely. I mean, when the barristers sort of using language that they think they understand but actually is being heard differently by the jury, as they did in Kathleen Folbig's case, then, what hope has the jury got?
Well, the barristers didn't really understand the word either, it seems.
And the particular thing in that case, and the particular phrase that was used hundreds of times, was that the findings in relation to the babies in the Folbig case, the four babies, or 3 babies and 1 18-month-old toddler, the findings being no findings, no injuries, were consistent with smothering, or words to that effect. And consistent with, when that's a phrase used by somebody like myself, trying my very hardest these days to never use it, means that it's possible. So if the findings are consistent with smothering, then I would say another way of saying that is smothering is a possible explanation for the findings. But lay people, and this has been demonstrated in research, here consistent with as equal to, the same as, means that A means B. So the jury would have heard that as the finding meant smothering. The findings were equal to smothering. So there was a complete disjunct. And the barristers and the judge would have been hearing something in between, presumably. So it was a complete schmozzle. And the same thing might have happened in Keogh's case. It would be interesting to go back and actually see the precise words that are in the transcript of what Manock said, whether he said it was consistent with a grip or whether he said he thought it was a grip.
And was there any other evidence in that original post-mortem, like internal injuries, water in the lungs, neck trauma, that supported either the theory of a drowning or the theory of a staged murder in the bath?
Yeah, well, I would have been, and I did say in evidence, I was quite happy that the diagnosis was drowning, and she could easily have drowned accidentally. She stood in a bath, she fainted, she fell over backwards and hit her head on one end of the bath and stunned herself and head under the water and drowned. And you can, in those circumstances, drown very quickly. And that's what I think happened. That's what I said I thought had happened. And as I say this to you now, I just cannot believe that a jury and an absolutely top-of-the-range barrister that Keogh had in that trial went with the prosecution.
Yes, you have to wonder at the time whether there are other factors circulating, like the factors that led to the conviction of Lindy Chamberlain, where there were all kinds of ideas about how she was acting in the witness box.
And what the newspapers are saying and who's controlling the narrative outside, yeah.
Now, there were missing, or at least insufficient, histological samples in this case, weren't there? Samples of tissue. Is that right?
The number of actual histological samples, which is little pieces of the organs, lung, liver, kidneys, pancreas, brain, prostate, bladder, skin, muscle, tissue that might ordinarily be taken in every case. In that particular case, I think there might have only been 5 or 6 samples taken, one from each of 5 or 6 organs, something of that order. I don't hold me to the specific, but there wasn't much in the way of histological coverage. Dr. Menock himself would not have said that he was a histopathologist, I think. And there was subsequently a lot of debate about the adequacy of the autopsy generally, and one marker of that was the small number of histology samples that he took. Now, again, at the trial, I said that I was content with the material that was available from the autopsy to come to the conclusion that it was a drowning. So I was offered the opportunity to say that I thought the autopsy was inadequate, and I said I felt that it was of sufficient quality for me to conclude that Anna Chaney had drowned. So you're right, there was debate about that in the subsequent to the trial as retrials and appeals were held, and all sorts of proceedings involving, I hesitate to think how many sets of legal proceedings there were over the following 20 years.
And his murder conviction was finally overturned in 2014.
Yeah, it was overturned after the law was changed because of the work of Bob Moles, which allowed people with fresh and compelling evidence to get their cases back into the courts.
So, Stephen, another very famous case that you've been involved in is the murder trial of the New Zealand eye surgeon Philip Polkinghorne, who was accused of strangling his wife and staging her death to look like a suicide in 2021. Can you tell us a little bit about that case?
Liz, this was a woman who'd been married to the accused for decades, a relationship where there's no record of any violence. There was sort of an open element to the marriage, and it was those sorts of details which made this case great newspaper material and generated a huge amount of public interest. But from my perspective, the case was extraordinary because of the charge being murder by strangulation, as you said, versus the fact that the unfortunate woman was found hanging. And that is a absolutely classic situation to differentiate. And every time, and hanging, of course, is a very frequent event. Suicide is a very frequent event. Unfortunately, it's much more common now in our community than road traffic accidents. So forensic pathologists get very familiar with suicide. So from my perspective, it actually was fairly straightforward because I was quite comfortable and very comfortable with the conclusion that Mrs. Polkinghorne had committed suicide, and very comfortable with the conclusion that you could not properly conclude on the material, there was absolutely, plenty of forensic pathology material, so there was no shortage of that. You could not properly conclude really in any way that she had been strangled either manually or by a ligature.
You said, or you argued, that there were certain injuries that you would expect to see if there was a violent strangulation. And what would they have been?
Commonly, people who have been homicidally strangled, but no better way of saying it is having their neck compressed. It's often the end of a more prolonged assault. So very often in such cases you find bruises and abrasions and even lacerations to the face, the head, chest, arms, as these suffer injury as a result of usually a blunt force assault with fists or feet or some other blunt weapon. Now, there wasn't a single one of those, so whatever had happened here, there was no evidence of any assault. So, you all of a sudden you've reduced this case to a very unusual rump of cases where somebody has been taken unawares and successfully strangled and hasn't been able to mount any defence because Mrs. Polkinghorne had no such injuries. So that sort of sits there because it is possible to, as sometimes happens in circumstances of law enforcement restraint, that arms are put around necks and minimising injury but causing effects on the consciousness of the person being restrained by police. So those sorts of considerations come into it. But then on the other side of the ledger is that everything at the scene conformed absolutely with what you would expect to find in somebody who had, unfortunately, suicidally hanged themselves. So that's how it sort of, that's how the calculation, if you like, pans out. There's a lot of material and observations and conclusions that point away from homicide, and a lot of observations and conclusions that point towards suicide. So in the context of a trial, to the extent that the pathology is important in the case, it's a sort of open and shut situation.
It seemed that, in fact, your pathology evidence was pretty crucial in explaining what had happened. You talked about the lividity in the body, the post-mortem blood settling, and also the body position. Can you explain that?
Yes, the lividity being the sort of settling under the influence of gravity, the passive settling of the blood after death in whatever position the body happens to be. In this case, the pattern of the lividity, the way the blood had settled, the parts of the body in which it had settled fitted with the way the body was found. So it wasn't the case that there was any evidence that the body had been in some other position, if you like, for some time before being placed in the position in which he was found after death. So that was the sort of modest contribution, I suppose, to the validity of the thought that she had suicidally hanged herself. And as, of course, when you say what effect all of this has on the jury, nobody knows, of course, and the jury's not allowed to say anything about why they come to the conclusion they do. But it's important to remember that the prosecution pathologists never actually said that she'd been the victim of a homicide. So the prosecution pathologists were quite circumspect. And of course, the degree of circumspection allowed, to a certain degree, the possibility of homicide. And I think they allowed that possibility. And I myself couldn't completely rule that possibility out. But that was sort of a matter of emphasis, I suppose, that might have differed between me and the prosecution pathologist. But prosecution started the case without a pathologist saying, well, this is a homicide. They were probably going to be pushing a bit uphill right from the beginning. But, of course, the public clamour was pretty loud.
You said that the pattern of this lividity, which is something you can see on the outside of the body, isn't it? It's a colouring and a shape. Is that correct?
Yes. So it's like congestion, really. So if you are lying on your back after death, let's say you've collapsed and fallen on your back as you've died, and you lie on your back for 6 to 12 hours, and then somebody comes along and finds you, then the front half of your body, that's the belly, for example, will be very pale, but your back will be quite dark red to purple, because that's where all the blood has settled to, except that is for the areas of your back that are in contact with the ground, because in those areas the blood vessels are compressed and the blood can't get into them, so they look white. So you get this sort of quite characteristic appearance when it's a body lying on its back on the ground. You get these what's called areas of pressure whitening against a background of quite dark red or purple, areas of the back that weren't in contact with the ground. And you can be sure that for some hours after death, that body's been lying on its back. So in this case, and in often the case in hanging, there is lividity in the legs, lower legs, and lividity in the hands and forearms.
In this case, you testified the pattern was consistent with the dead woman having been seated, which matched Dr. Polkinghorne's account of how he found her.
Yes, it did. I just note in terms of this program, Les, how, and I'm not, how you said consistent with, I probably did say that in the trial. It just shows how difficult it is to avoid, sort of ingrained in the way we talk sometimes. But it fitted with the pattern of lividity. It could have occurred as a result of the way he said he found her, which was sitting in a chair, and it fitted quite well with that.
And were there any injuries that could have pointed to foul play?
Well, I put it this way, which was if I had been to that scene, having seen what was described and seeing the photos after the police arrived, I would have been, quite happy to regard the scene as one of a suicidal hanging.
So, Stephen, when you're called to give evidence in a case that is as publicity attracting as this one, does it feel different?
Not really. What was different was there were a lot of people in the courtroom, and it was being live streamed, I think. So that was a bit different. But no, I don't think it really does. You sort of settle into, the giving of evidence that you've done many times before, and you've put a lot of work into the preparation. Even though I regarded it as a fairly straightforward thing, it still took a huge amount of work, because what is normally straightforward is all of a sudden being put under quite a substantial microscope, so you've got to really dot every single I and T of what is taken for granted in uncontroversial settings.
In this case, it seems that the jury accepted the defence view of what had happened in that they did find Dr. Polkinghorne not guilty.
Yes, and they accepted the defence view. What I'd just like to say about that is it's a real pitfall, a real trap for any witness to get into. I take no personal comfort from the jury's verdict about my evidence. My evidence has to stand or fall in the court of my peers and my colleagues. The day a witness starts thinking, oh, well, the jury came to this or that decision, that means that they agreed with what I said, therefore what I said was right and good. The day a witness goes like that is the day the witness starts going downhill, because that is not a validation of the evidence given. The jury, as you correctly put it, agreed with what the defence put to them. That is, I think, a different conclusion and the right conclusion of what the jury did. But witnesses should take no comfort from a jury decision about their own evidence. And that also means that if the jury come to a decision which is against what you said, you shouldn't actually necessarily take an adverse view that means what you said was wrong.
As in the Keogh case where you testified it was your belief that this was a terrible accident and the jury clearly decided otherwise.
Yeah, and, we're supposed to be disinterested. And it is the case that often after giving evidence, I would never hear what the result or outcome of the case was, and sometimes you'd see it in a newspaper, but generally speaking, occasionally you'd sort of try to find out what happened, but most often not. You either heard about it or you didn't. So I do think if there are any witnesses, expert witnesses listening to this, and you're sort of beaving around always trying to find out what happened in your cases, you just need to ask yourself whether you're doing that for the right reason. Because if you're doing it for some sort of self-validation, then that's the wrong reason.
Well, thank you so much, Stephen. As always, it's incredibly interesting to talk to you, and thanks for your time.
Oh, look, it's a great pleasure. Liz, great to chat to you, and I look forward to seeing you around somewhere soon.
Crime Insiders Forensics is hosted by me, Liz Porter. It's produced by Holly Mitchell, Jade Murray and Dan Mullins. Sound design is by Niall Fernandez. This podcast is produced on Wurundjeri and Gadigal lands.